Hello, this is Chris Kane with Adams and Reese. I'm a partner team leader of the Global Transportation and Logistics team. And I'm joined today with Michael Berson, who's a partner of ours out of the Mobile and DC office who specializes in SBA related issues. And we also have Greg Rouchell, a partner who is the team leader for our labor and employment team. And we come to you to talk about some very important decisions we recognize that a lot of our clients are making in this period, prior to the effective date of the paid sick leave legislation under the Families First Act, and wanted to provide some information related to the bill that is currently going through Congress and is anticipated to be signed today, March 27th, hopefully later this afternoon, in the Paycheck Protection Program, and how that interplays with some of your decisions in terms of keeping folks on your payroll or furloughing or potentially letting them go. And our goal today is to provide you with the information, again, that is in the current act as it sits going through Congress and hopefully is enacted and signed by the president later today. As a caveat, this is important, as this legislation is eventually enacted, there's going to be a component for the administration to provide and promulgate rules, which will provide ultimate guidance in terms of how this program will be played out and we'll have to follow. There is some questions and interpretations that are left in the text of the language. And so that's going to be very important to come out, and we anticipate that it's going to come out, if all things go well, some point in time next week, hopefully earlier rather than later. And we'll have to obviously evaluate that on a case-by-case basis for each scenario that may be specific to you. However, we do have enough guidance that we do understand, based on the language of the CARES Act, which we'll talk about in a second, that the secretary and the administrator are given some pretty broad discretion in terms of interpretation and implementation, especially due to the crisis that we're all facing. So with that, just very briefly, I think it's important to understand what exactly is in front of Congress today and hopefully being signed into law by the president later today. The Coronavirus Aid, Relief, and Economic Security Act, which is better known as the CARES Act, includes in it many provisions, and we're going to have more information as time comes related to the entire legislative package. However, for today, again, what we want to focus on is really two key components of that total package. The first is the Paycheck Protection Program, which is a $350 billion program that is going to be funded through the SBA and specifically utilizing a component of the SBA regulations called the 7A loan program. The second is there's tweaks to and legislation related to the Families First Act, which passed last week, of which Greg previously provided a webinar on, and we've sent several alerts out and update you on what this act does to that, as well as some recent guidance from DOL and from the IRS. So with that, let's talk about the Paycheck Protection Program just in general. Again, it's, as I mentioned, it's a $349 billion aid package for small businesses. The total package of the total price tag on the CARES Act itself is approximately $2 trillion. So this is, while $350 billion is certainly a significant amount, it goes to illustrate that there's a lot more, obviously, in this package. And again, we will talk more about those in terms of applicability from a standpoint of other programs, should this not apply to you or be of benefit. The purpose of this, it's a very unique program in the terms that instead of like most SBA loan programs that are more like a traditional loan, but in extreme circumstances in terms of disasters or for certain encouragement of certain types of small business activity, this in essence is acting as a recovery and gap tool for business interruption for small businesses for a period of time. The time period of the program dates back retroactively to February 15th, and it goes through June 30th. And as you'll see, this is a 100% federally guaranteed program that is going to allow for you to do a number of things in order to access capital fairly quickly we believe, and if the program is run as designed by the Act, there is a pretty tight timeline in terms of getting dollars that you're eligible for into your hands. And then there is a component at the back end in order for this to be forgiven and truly to be the gap funding, that interruption type funding that you very well may need to where it's forgiven. That, again, a high level standpoint, that's what we're talking about, and let's talk about those specifics. And I'm going to ask Michael to discuss who is eligible under what we're calling the PPP.
Thank you, Chris. So with regard to eligibility under PPP, this is available to those small businesses who are currently already eligible for SBA loans prior to this COVID pandemic. This includes, all business concerns that employ less than 500 employees, as well as 501c3 nonprofits employing less than 500 employees, and also in circumstances, certain industries where they employ greater than 500 employees, but there are no more than 500 employees at a given physical location. This is something that was essentially kind of carved out a little bit for restaurants and hotels, given the way that they're currently structured. But what they're trying to do with some of these eligibility criteria is they're trying to make this as broad as possible. I think they're trying to define small businesses within the parameters that are currently allowed under statute as broad as possible as they try to prop up and support this entire segment of our economy. And then, kind of going back to what Chris said a few seconds ago, having it be retroactive as well will certainly help, especially those folks in the restaurant and hotel industries, as we've seen from state to state or even from city to city, these kind of stay-in-place orders that have gone into effect.
Yeah, and Michael, I'll add as we were talking about the purpose of the PPP is to be more expansive than your traditional SBA program. So what we're seeing in the Act, and again, the guidance is going to dictate ultimately how it will be applied. But what we're seeing in the language is this: if you were eligible under the existing SBA rules, then you're still going to be eligible. What they do is they then say, okay, but anybody who employs less than 500 people, they're eligible. That's important because there are under the ordinary rules, there are NAICS code restrictions based on what type of business you are, and those are either assigned to revenue or they're assigned to a job number, which could be less than 500 or could be more than 500. What this legislation does is it says we're gonna disregard parts of that of those prior restrictions, and we're going to say if you have 500 employees or less, you're going to qualify. And also, if you have an NAICS code that is higher than 500, then we're going to acknowledge that limit and consider you to be a small business. So it's excluding areas where you would see a limitation on small businesses under 500 employees and an inclusion of instances where you could have over 500 employees. So, again, you need to be a little careful and talk through scenarios here because you have a number of factors that could come into play as it relates to things like affiliated entities and the like. And so, we want to be a little cautious about a general rule here. But if you have less than 500 employees, or if you're in an industry that has a higher NAICS code for employees, this is something you definitely want to take a look at and is an opportunity that you could very well be eligible under. Michael, what are the criteria under the PPP?
Excuse me, looking at how it's currently structured now and just this is how it's structured under the legislation, as Chris mentioned previously, we're still waiting on the House to pass this and for it to make to the President's desk. But as it's structured and as we read the bill, loans are capped at the lesser of either $10 million or 2.5 times your average total monthly payments for payroll costs that have been incurred during that 1 year period prior to the date the loan is made. There's a max interest. It's capped at 4% as well. This is something that a lot of staff time, a lot of effort, a lot of consultation with folks on the Hill and folks within the agency went through to put this type of criteria together that we think is broad enough to really kind of encompass a lot of the needs that we're seeing from small business throughout the country. In addition to those, the loan payments are going to be deferred for at least 6 months, but they cannot be deferred for more than a year. That's certainly an important thing. And unlike some traditional SBA loans, borrowers, they're essentially waiving or exempting. Borrowers are not going to be needed to establish that they are unable to secure credit elsewhere. That's a certain criteria that some folks may find in the EIDL program, which is the Economic Injury Disaster Loan Program. And also the businesses, in addition to the need not to establish to secure credit elsewhere, they won't need to establish credit worthiness or their ability to repay. SBA and the Hill and Congress have realized the situation that everybody finds themselves in. So what they're doing in this legislation is that they're allowing SBA to essentially make a relevant inquiry into whether the business just existed as of February 15th, 2020, and if you were paying employees at that time.
So, right. So a couple follow-ups there, and let's just use an example. If you were an eligible company and you have a payroll of $100,000 on average over the last 12 months, then you're going to be eligible for a $250,000 loan under the program. And you're going to be able to defer any payments for the next 6 months. And we're going to talk in a second about the forgiveness component of this. But in essence, you in theory will not have to pay payments until after that forgiveness period, that you'll be equating what would be eligible expenses to be eligible for the forgiveness will occur before any payments are due. So that's an important part of it from a standpoint of cash flow and the intent of what they were trying to accomplish in the PPP. So just note that, and these other waivers we're going to talk about are critical too. And Michael, you go ahead and follow back up where I kind of cut you off.
Sure thing, Chris, and thank you for helping provide some details and some examples there. Just a couple other items to mention with regard to criteria. And again, this is kind of a high-level overview. Unlike some of the traditional SBA loans, they're also not requiring collateral to secure the loan, as well as no personal guarantees are going to be required. This and the last item is something that we definitely want to point out. Essentially, there's no double dipping. So you cannot use, if you're successful in obtaining a PPP loan, you cannot use those funds to pay mandated sick leave under the Families First Act. Rather, and Greg will get into the specifics of this here in a second, rather those tax credits under the new paid sick leave laws are going to really be your sole source of reimbursement for those types of expenses. Going into the acceptable uses or items that loan proceeds can be spent on, I'll touch quickly on just a couple of the notable exceptions. Individuals making more than $100,000 per year, certain withholding taxes, and then sick leave that is already provided for by the Families First Act. Those are some exceptions under payroll costs. Other acceptable uses, the group health care benefits during the period of paid sick, medical or family leave, as well as insurance premiums, of course, employee compensation, mortgage interest payments, but only if the mortgage was in place prior to February 15th, 2020. It's that date again, that effective date again, essentially. Rent, but again, only if the lease was in effect prior to February 15th, 2020, and utility payments. Those are going to be your acceptable uses of those loan proceeds.
So again, going back to the example we had earlier, we talked about taking your payroll, your average payroll of $100,000, multiplying it by 2.5 or 250%, and coming up with a available loan of $250,000. You would include our appreciation of the rules, again, subject to guidance, is that you would include all of your payroll. There would not be exclusions for payroll over a certain amount in order to determine your loan amount. However, on the acceptable uses, what you could use those funds for, there would be exceptions and limitations related to payroll specifically. However, you then can use your loan for a whole host of other fairly significant general overhead items, and that's what Michael was just describing. So pretty significant opportunity. And Michael, at the end of the day, with the program ultimately, the reason why it's so attractive and has such buzz is because of this part, the loan forgiveness. Can you tell us how that works?
Sure. So the loan forgiveness part, and Chris is absolutely right. This is very, very attractive and will be for a lot of small businesses. So speaking, of course, in generalities, and we still don't have that final guidance from SBA yet, but the amount of the loan forgiveness essentially cannot exceed 100%. Only the following will count towards that loan forgiveness figure. Payroll costs, however, it's just the payroll cost during those 8 weeks following the actual loan origination date. Mortgage interest is another item that's going to factor into the actual forgiveness figure, but only if the property was purchased before, again, that February 15th, 2020 date. Similarly, rent, and again, if that lease was in place before that February 15th, 2020 date, and utility payments, and this is kind of mirrors the payroll costs criteria during the previous 8 weeks following the loan the loan origination date. So those are going to be the factors that they're going to include into the loan forgiveness amount. It's also, and this is going to be very important to know and understand, and this is, again, just kind of our reading of the legislation as it currently exists as being passed by the Senate right now. It will be subject to a workforce reduction. So if your workforce headcount is less during the relevant period, so from February 15th to June 30th, as opposed to the previous year, what they're trying to do here is they're trying to keep as many employees on staff, employed, and paid as possible. So also by making this retroactive, what they're doing is that if you've already laid off employees, you won't be penalized if you rehire them. They want you to bring some of those employees back onto the payrolls. Similar reductions of the amount of loan forgiveness may also be triggered if you reduce your employees' compensation during this relevant period, and they're going to compare that to the previous year. And similarly, if you've already laid off employees, you will not be penalized if you kind of bring them back on board. Employees will need to fill out paperwork to establish the amount of the loan and the amount of loan forgiveness. That is something that is being worked on right now exactly, and we'll have some more clarity as soon as SBA puts out guidance and as soon as we have a final bill so they can start really working on that guidance. And also this is something important as well. Any amounts remaining after the forgiveness must be repaid no later than 10 years after being borrowed, so after that origination date.
All right, Greg, before we move on to you, just a couple of mechanics that we've spoken to some of the SBA lenders who are already authorized to issue 7A loans, and again, our own evaluation of the act as it sits now, and again, waiting for guidance from the SBA, it is the functionality of it. So you're going to be sitting there perhaps thinking, well, what do I do? The thing to do right now is first let's get the president to sign hopefully a final passage bill into law some point in time today. But if you have a relationship with your lender and your lender is an SBA certified lender, then it's a good idea to reach out to them and to begin having discussions. Now, importantly, they've structured this act, this program, to not have to go through a certified SBA lender and open it up to non-certified SBA lenders as well. And the purpose of that is to provide as many vehicles as possible in the marketplace to apply for 7A loans under this program and to deploy capital. And again, that's a good route to go. However, if you're thinking about it from a standpoint, if you've got a relationship with a lender who's already certified to do SBA lending, you may have a quicker route there to take. And there's a host of information that you would typically pull together and provide to your lender when you're applying for a loan. And that's good to begin to do now and get ready, which will include things typical like your financials and information related to your company for underwriting of even an ordinary loan. Although, again, there's going to be some significant waivers, which we've just reviewed. Now, turning to another important part of the CARES Act that plays into the decision-making you're likely going through right now in terms of what do I do with my employees next week or the following week, is the is how the CARES Act, and particularly how, I guess, ultimately the Families First Act is going to be effective and implemented. And Greg, if you could take us through how the Senate version of the bill and what's in front of the House right now treats the Families First Act and what guidance you can provide there.
Sure thing, Chris. Well, I think a lot of employers right now are asking themselves, okay, wait a second. I was a little freaked out a couple of weeks ago because I found out that I'm now going to have to be required to pay mandatory sick leave. And so a lot of employers are making some difficult decisions about potential mass layoffs or continuing to keep people on the payroll. And so now that begs the question, well, wait a second. If I can get an SBA loan, maybe that'll help ease some of my fears and the financial burden of, what was previously, scaring me in terms of my ability to make payroll. And so I want to make sure that everybody realizes who's listening that these SBA loans through the PPP is completely separate and apart from the paid sick leave tax credits. In other words, you're not going to be able to use the SBA loans to pay the mandated sick leave. But Congress, specifically the Senate in this latest bill, they did some tweaks to the tax credit component for the mandated sick leave. And I'm going to talk about those in a couple of minutes. But I just want to make sure everybody realizes that you can't opt to use the SBA loan in lieu of the tax credits. You have to still use the tax credits. I also wanted to make clear to everybody, and in case you did not already realize this, that the Department of Labor has issued some very helpful guidance, which can be found at that link we provided right there. It includes fact sheets for employees, fact sheets for employers, lots of explanations. There's a Q&A page that contains examples, and it also has the required posters. So for anybody who is going to be subject to these new paid sick leave laws, you're going to be required to issue and post certain signage with your other posters, like your workers' comp and your FMLA posters. You're going to have to include this poster with your other postings. So a lot of folks are also wondering about the interplay between the CARES Act and the Family First Coronavirus Response Act, meaning the mandated paid sick leave. And so I wanted to walk everybody through the practical mechanics of how this would work for you and your business. So again, because there's no double dipping, this is how this is going to work. At least this is what we think at this point in time. This could change once the guidance comes out. But based on what we know now, if you're required to pay sick leave under the Families First Act, and again, there's two components to that, and we talked about that in a prior webinar, as Chris mentioned earlier. There's a Emergency Paid Sick Leave Act, which is going to apply when there's one of six or a combination of six triggering events, and you're going to have to pay your employees up to 10 days is really the practical effect. It says up to 80 hours of mandated paid sick leave, depending on the circumstances. And that's typically when an employee, for whatever reason, has to remain at home and they cannot work and they lack the ability to work remotely from home. And so to sort of ease the burden for you on the tax credit issue, what the Senate did through the CARES Act is they implemented two additional provisions, basically saying, don't worry, if you don't deposit your quarterly payroll taxes to the United States Treasury, we're not going to penalize you. You don't have to do that anymore. And there's a second component, a second addition that says we're going to give you a, quote, advance on the tax credits. And what that is going to do is allow you to immediately take advantage of the tax credits that are potentially available to you without having to fill out paperwork. You'll fill out the paperwork on the back end, but the funds are immediately available to you. So what does that really mean in practical sense? Congress wants you to pay your employees for the paid sick leave instead of paying the government your quarterly payroll taxes. They're advancing the quarterly payroll taxes to you as a credit and allowing you to use that money to pay this mandated 10 days of sick leave. And so separate and apart from that, to make sure everybody understands, is that that's with regard to the paid sick leave. And remember, there's two components. In addition to the 10 days, you also have up to 10 weeks of additional paid leave for the child school closure issue, meaning school is closed. You have to stay, the employee has to stay home to care for the child. There's no other option for anybody else to watch the child, essentially, and the employee cannot work remotely. So the tax credits would likewise work to reimburse you and provide an immediate, quote-unquote, loan that is likewise, in essence, being forgiven, because instead of having to pay your quarterly payroll taxes to the Treasury Department, you're going to use that money to instead pay your employees their mandated sick leave. And then separate and apart from the sick leave, we have your regular wages and payroll, which is what Michael has been talking about, that you're going to be able to fund through these forgivable SBA loans. Finally, I wanted to point out a couple of amendments to the mandated sick leave rules that the Senate implemented in this latest bill. Most notably is the FMLA component to the paid sick leave, meaning the 12 weeks where the first 2 weeks are unpaid and then the final 10 weeks are paid. Again, this is the scenario involving a school closure, the employees having child care issues, and they cannot work remotely. If you laid off employees between March 1st and April 1st, which many of our clients have done, particularly in the hotel and restaurant industries, if you decide that you want to take advantage of these SBA loans and you decide to hire people back, just know that if you rehire them back, you're going to have to honor that 12 weeks of FMLA, that expanded FMLA leave for the school closure child care issue. And basically what Congress is doing there is saying, wait a second, you can't lay everybody off and then take them back and get the SBA loan. You can't have it both ways. If you take people back, you're going to have to at least honor the 12 weeks of expanded FMLA leave. And then the final thing I wanted everybody to realize is that they inserted a provision at the end, which may seem rather innocuous at first glance, but I think is significant. It authorizes the Secretary of Labor to conduct audits and investigations just as they can under the Fair Labor Standards Act. And I think that the message there is that you need to make sure that your documentation is in order when you take advantage of these advanced tax credits, and also when you apply for your disaster relief loan through the SBA. Because what I think is going to eventually happen when all the dust settles is there's going to be, unfortunately, businesses and individuals who try to game the system or engage in fraud. And I think the government wants to have the ability to go back and investigate, and if they find that there was fraud or abuse, they will seek to recoup any funds that were wrongfully taken advantage of by employers. So the message there is documentation is extremely important, just like it is for your ordinary payroll practices under the FLSA.
Thanks, Greg. And before we wrap up, I just want to mention that under the CARES Act, if you're not eligible for the PPP, again, there are a number of other programs that are being supplemented, appropriated, and rules promulgated for within this legislation that may apply to you. We thought it would be best suited to get you this information as quickly as possible because of the important decisions you have to make. But you'll hear other things about the economic injury loan disaster program, as well as the employment retention tax credit. These are other programs that may fit your needs, but most folks are looking at this PPP as an opportunity to basically utilize, at the end of the day, forgiven loan. It looks like a grant, basically, if you follow the rules and you're eligible. So again, that's why we wanted to make sure you had this information and how it interplays with the passage of the bill last week and the paid leave component. So we appreciate your time, Greg. Michael, thank you for your time. We're here if you have any questions and want to go through your scenario. We understand that there's a lot of information coming at you as well as coming at us. and we're digesting it as quickly as we can in real time. So we, again, appreciate it and look forward to hearing from you with any questions you may have. Thank you.